Hi friends, this is Suman Dash Vidya-mitra, Assistant Professor of Law at National Law University, Odisha, Cuttack. And today I am going to discuss with you one of your modules in the course for Advanced Jurisprudence, which has been titled Natural Law in the Medieval Era. Before we begin with the nuances of this module, let me first introduce you to the topic. After the Greeks and Romans, the conception of natural law gathered importance in the medieval era. During this time, natural law was further refined to acquire new meaning in definition and content. So when we talk about the Greeks and Romans, we discuss the idealistic values that they had instilled into the system of law, into its idea, denotation and connotation. Those idealistic values for some period of time were continued in history through the Dark Ages into the medieval era. And over a period of time, natural law started acquiring a new form, a new shape, and its definition, content and meaning started acquiring several changes, several layers started being added to it, and many others at the same time were being removed from it. Concepts like divinity, virtue, and values seeped deep into the notions of law and justice. The medieval era, as we will see in the next few courses of our lecture, was characterized by a very strong emphasis on value system, morality, religion, and ethics. This has been reflected in the idea of law and in the idea of natural law as it exists in the system today. The idea of state also simultaneously underwent a very significant change, and religion heavily influenced the notion of law. Now that the instrumentality of law was getting changed, it was but obvious that political institutions, other human institutions also underwent some change. And we'll figure out what exactly the details of those changes were. Apart from that, a clear-cut demarcation was made between laws that were temporal and those that were eternal. Actually, this in the medieval era laid the foundation of natural law. This difference between the temporal and the eternal was the justification for the existence of natural law. The idea of natural law was linked with ultimate completion, perfection, and godliness. So, as I said earlier as well, the idea of natural law, or law for that matter, in the medieval era was linked with the Almighty, was linked with religion, was considered to be sacrosanct and sacramental in nature. And this is where the idea of natural law also got linked up with the ultimate idea of completion or perfection. As we proceed into the details of each of the things that I mentioned to you, I think it would be beneficial for us to look at the objectives of this course. The first objective of this course is to acquaint students with the teachings of primal medieval philosophers. Apart from that, the module also intends to familiarize students with the developments in the concept of natural law during the medieval phase. The third and most important objective of this module is to inculcate an understanding of the famous debates that happened between and among different philosophers in the medieval era. To have any kind of discussion about the medieval era, it is but important for us, and in fact something that we cannot ignore about the medieval era is the introduction to the medieval era, which was the prelude to the medieval era as well. And when I talk about the prelude to the medieval era, there is nothing but the Dark Ages which come into the picture. So between the philosophy with which the Greeks and Romans had put forth before us and before the dawn of medieval era, we had the Dark Ages in between, where the traditional values of philosophers like Plato and Aristotle and other classical Greek and Roman philosophers were carried forward for some period of time by certain other philosophers, and from them or from their ideas we then have medieval philosophy coming exactly into the picture. So, the most important philosophers who built the bridge between the Greek and Roman era, between the classical era and the medieval era, were in the Dark Ages, were philosophers like Saint Augustine, Saint Ambrose, and Saint Gregory. They were also the forerunners of the Dark Ages. They continued the tradition established by philosophers of the repute of Plato and Aristotle, and their significant contribution was in that they started adding new layers of philosophy to existing ideas of natural law. Now, the Dark Ages has been characterized by certain significant features. A. There was emphasis on scriptures. B. The idea of sin was very much integral to the concept of law. C. The emphasis was a lot on moral precepts which were contained in scriptures. And D. Emphasis therefore was also on the church as the most important human institution. Now, to begin with, the emphasis on scriptures also led to the emphasis on moral precepts contained in them, and this in turn led us to the idea of sin, purity, etc. And when we look at it from a holistic aspect, control of scriptures, the concept of sin, the concept of moral precepts was laid in the hands of the church. So primacy was given to the church because all other human institutions were supposed to be never capable of being good, and therefore they had to be controlled. To begin with, let us take a look at the most significant philosopher who came across, who was Saint Augustine. Now, in the Dark Ages, Saint Augustine was one of those philosophers who carried forward the concept of natural law, and his philosophy began with a comment on the existing human institutions, their necessity or their relevance to human society. So Augustine remarked that human institutions become necessary only when men fail to adhere to Christian values. So in other words, Augustine was a firm believer in the fact that human institutions are nothing but a necessary evil. He also believed in the idea that there was once a golden age of mankind where there was absolute purity, complete lack of vices like inequality, institutions like slavery didn't exist during that period of time, and institutions did not exist. Human institutions like the state, the government, etc. were never really necessary in the golden age of mankind because of the simple reason that they were not relevant. Human beings themselves were so pure, so perfect and complete that they never really needed the control of a human institution. So Augustine's emphasis, as we can see, was on the fact that morality and human values, as long as they are existing or are present in a system, you do not require institutions to control human beings. According to Augustine, during the Golden Age, not even the idea of death existed. The bondage of death is considered to be one of the most important bondages which no philosopher till date has denied as being existing. But Augustine's idea, like that of a utopia, was that in the golden age of mankind, we didn't have the concept of death existing. Augustine continued his philosophy by stating that in the golden era, commonality of possession was enjoyed, by which he inferred that there was no question of disputes arising in relation to material aspects of life because people had the liberty to possess everything in common terms. Augustine also pointed out, like some of the other Greek and Roman philosophers, that human beings at that point of time, and therefore society as a whole, was under the constant guidance of reason. Now, in one of our previous lectures, we have already discussed that Plato and more importantly Aristotle was of the idea that man is a rational animal and that it is rationality which distinguishes human beings from other animals. Now, this is exactly where Augustine's teachings become relevant because he justified the existence of moral values in the purest of its forms in a golden age on the issue or on the basis that human beings have always been constantly guided by reason. Apart from that, Augustine justified the existence of a state, but the reason behind his justification of statehood was something phenomenal. He stated that religion was required to guide human institutions and therefore primacy ought to be given to the state. Primacy ought to be given to the church in this matter. Now, the state therefore necessarily had to exist as an instrumentality because it was necessary for the protection of the church, for the execution of the commands of the church, and for the preservation of general order in society that the church must establish its control. So, he justified the existence of statehood on the basis of three primary interests that had to be protected, which was number one, protection of the church, secondly, execution of the commands of the church, and thirdly, preservation of order in society. Apart from that, St. Augustine also distinguished between lex aeterna and lex tempora. According to Augustine, lex aeterna stood for eternal law and lex tempora stood for law that was temporal in nature. So, eternal law, according to Augustine, was a perfect piece of law or a perfect body of laws, whereas on the other hand, lex tempora or the temporal law was an imperfect body of laws. Now, eternal and temporal laws differed from each other in the sense that eternal laws were non-negotiable in nature, were universal in nature, were far more superior than temporal laws which were created or which had a modal source. After Augustine, somebody who followed the footsteps of St. Augustine was Isidore of Seville. Now, he was influenced by Augustine to a tremendous extent and had faith in the primacy of the church, believed that the church exists for the good of mankind and that the state should also exist for protection of the church, and through it, protection of order in human society. Apart from that, Isidore of Seville also contributed by stating that natural law springs from human nature and not from any agreement between human beings. So again, we find here a reiteration of the principles of or the philosophical content of natural law as has been exposed to us by many scholars who stated that natural law has a source which is beyond a mortal source. After the Dark Ages, we then had the dawn of medieval era. The rise of the medieval era has been a very significant chapter in the growth and development of natural law. And certain fundamental precepts or principles that we need to note about medieval era are as follows. First, the idea of natural law in medieval era or philosophical content of natural law in the medieval era started assuming importance and significance in terms of growth and development only in the 12th to 14th centuries. And the maximum momentum was in this era was gained in the domain of natural law in the teachings of Saint Thomas Aquinas. He remains the primal philosopher of this era, and his teachings are extremely significant for us to understand anything about the concept of natural law in the medieval era. Now, a very important feature about the medieval era and natural law in the medieval era was that there was an attempt to break law from chains of orthodoxy. Now, just before this, when we discussed about the Dark Ages, one thing that we came to notice was that the church was considered to be a supreme body, an unquestionable entity, and the Puritan society prevailed, where emphasis was on purity and completion, perfection, absolute idealism. However, the medieval era is an era where we try to strike a balance, where we try to get in touch with reality, which is where an attempt has been made to break law from chains of orthodoxy by medieval philosophers. The other important feature of the medieval era is that human institutions are not considered anymore to be products of sin. Rather, they were considered to be instruments of justice and order in society. Apart from that, another idea which started springing then was the idea that law was equal for everyone, which meant that the ruler and the ruled would be subordinate to the law in the same manner. And medieval philosophers also emphasized that the source of authority in every civil society would be the people. And they also approved of notions which were not earlier approved. So, for instance, in the Dark Ages and when the church prevailed over the concepts of a statehood, the notions of philosophy of law and natural justice, natural law, they would state that private property was something which has to be looked down upon, because a few moments back when we discussed about St. Augustine remarked that in the golden age of mankind, there was emphasis on commonality of possession, which means the idea of private property was not something which people or medieval philosophers were acceptable to. On the other hand, medieval era was more realistic in this sense of the term, because the medieval philosophers approved very much of the idea of private property, unlike their predecessors. So, the most important philosopher of the medieval age was Saint Thomas Aquinas. From 1226 to 1274 AD, his philosophy started ruling the domain of medieval era. Now, the first major contribution of Saint Thomas Aquinas was that he divided law into 4 different types. So, he divided them into eternal, natural, divine and human law. So, according to him, the 4 different laws that we were talking about are lex eterna, lex natura, lex divini and lex humana. So, eternal law, according to Saint Thomas Aquinas, was a form of law which was perfect. It was not known only to God. And according to Aquinas, natural law was when man interacted through reason with the cosmic law. He got acquainted with certain portions of the cosmic law, and that is what was understood as natural law. Divine law, according to Aquinas, supplements natural law and is revealed through scriptures, which are considered to contain the gospel of God. Human law, according to Aquinas, was created by a human being for common good. So, Aquinas also established a chain of linkage between the 4 types of laws that he discovered, or divided law into the 4. When he divided law into the 4 categories that he did, he started establishing a chain in all the 4 concepts. So, for instance, he would say that eternal law was flawless. When we say it was a perfect piece of law, what Aquinas meant by it was that it was a flawless piece of law, and that it was universally applicable, that it was the cosmic law which was not capable of having mistakes in it. Now, natural law, according to him, was a portion of eternal law. But how exactly did we get to know the eternal law? Because human beings are not completely capable of knowing the entire portion of perfect law. But when man interacts through his rational capacities, when he tries to know the cosmos, when he tries to decipher the perfect law, he gets to learn certain aspects of the eternal law. Those aspects of the eternal law which man gets access to through the instrument of rationality, according to him, formed natural law. So natural law also had elements of perfection in it, but was not entirely perfect. It was beneath the idea of eternal law, but was certainly superior to all other forms of law. Divine law, on the other hand, was something which Aquinas considered to be supplementary to the concept of natural law. Now, when we say it was supplementary to the concept of natural law, he meant by it that although man interacts through his rational agencies with the cosmic law, sometimes we need to refer to scriptures, because scriptures are said to contain the ultimate gospels of truth, the ultimate ideas and principles of what law should be and what an idea of perfect law is. So this is exactly where the divine law comes into the picture. So the do's and don'ts mentioned in the scriptures, they would all qualify as divine law. Human law, according to Aquinas, was a form of law which comes into existence in human society by a human being. Now, it is designed by a human being with the intention of causing common good to society. Apart from that, Aquinas divided the notion of justice into two primary parts. So, he divided it into distributive justice and commutative or corrective justice. Distributive justice, according to Aquinas, was a form of justice where every individual gets a share of rights dependent on his status. So, rights, liabilities, duties, functions, privileges would all be associated with the status of an individual, and his entitlements would be totally justified by the status that an individual has in society. On the other hand, commutative justice was otherwise known as corrective justice. According to this notion of justice, Aquinas meant to say that whenever there is a case of unjust enrichment, or whenever there is a person who has been a victim of some wrong, the state needs to take action for restoring justice to the individual, or by causing some sort of loss to the person who has the unjust enrichment. So the wronged individual is restored with justice by certain forms of negative actions which are taken against the wrongdoer. So this is the idea of commutative justice or corrective justice or restorative justice according to Aquinas. From 1290 to 1349 AD, we had John Duns Scotus, another important medieval philosopher in the picture. Scotus was a Scotch Franciscan monk, and he is credited with generating the idea that will dominates reason and not vice versa. This is exactly the converse of what Aquinas taught, because in Aquinas' teachings, what we can notice is the dominance of reason. He believes in the rationality of mankind, and that every good or bad comes from or has its origin in the rationality of man. On the other hand, according to Scotus, it is the will of a human being which controls every action and also dominates reason of human beings. According to Scotus, power and justice coincide only in God, as there is no law above God, and therefore his will is absolute. So he believed that the coincidence of or the confluence of power and justice is possible only in the perfect entity and not in imperfect entities. And he also said that there is only one principle of natural law, which is to love God. We then have in the picture a third medieval philosopher who was equally important, and he was present from 1240 to 1349 AD. He was the William of Occam. William of Occam has been credited for his teachings on natural reason and natural law. So he said, universal rules of conduct are dictated by natural reason. Rules may be deduced from general principles of the laws of nature, which are not fundamental in character and are liable to modification by authority. Apart from that, natural law cannot be discovered by human beings. Now, a very important segment in the entire lecture that we discussed throughout is the very famous debate between nominalists and realists. In the medieval era, we had two primary segments of schools of thought which came into the picture. The first segment was the segment of nominalists, and the second segment was the segment of realists. Now, the concept of realist philosophy, or the content of realist philosophy rather, was based on the notion that a parallel world exists, a world which is parallel to the world that we live in, to the real world that we live in exists, and human beings, being rational creatures, are able to have mental representations of that parallel world. In the parallel world, things are far more perfect than what they are in the real world, but at the same time, the other world is reflective of the world that we live in, or the real world. Being reflective of the real world, it also has certain principles, philosophies, or certain things to contribute to the emergence of philosophy in the real world, which means that realists believed that individuals are capable of learning certain things by having mental representations of the real world, and the only way to communicate with this other parallel world is through the instrumentality of rationalism or reason. Now, these realists laid down that when we have mental representations, we get to learn certain things from the parallel world, and accordingly we formulate principles, we emulate certain principles based on what we learn from the real world, based on what we learn from the parallel world. These mental representations can be actually applied in real life, and they would contribute to the philosophy of natural law. So apart from that, we had the nominalists in picture. These nominalists believed that universal principles do not exist. Even if they do, they are mere nomina, or they are there for namesake only, because according to them, the real world is only what we can perceive through our senses. So while the nominalists believed that universal principles are existent only for nominal purposes, realists believed that universal principles are gifted to us and are comprehended by us from the parallel world that exists, and these mental representations like virtues of love, affection, equality, virtues of doing good to others or correcting the wrong done to another are something that we get to learn through our mental representations by the modality of reason, or the instrumentality of reason. The nominalists and realists never really agreed with each other, and this led to a lot of debates which came up in the medieval era. However, it is the content of these debates that has contributed significantly to the content of natural law. Now, at this point, I think it would be pertinent for us to conclude, and by doing that, we would summarize the points that we just went through in this lecture. In the Dark Ages preceding the medieval era, natural law was linked with the idea of divinity and was said to be captured in the scriptures, which therefore could not be violated. The church dominated the areas of law and justice, and also guided the course of politics in the Dark Ages. Saint Augustine evolved the concept of original sin and stated that all human institutions are the product of sin. Augustine also justified the existence of the state on the ground that it was an instrument to defend the church. After the Dark Ages, the medieval era dawned with the teachings of Saint Thomas Aquinas. He laid the foundation of his teachings by delinking the idea of political institutions from the concept of sin. Aquinas linked law with rationality, distinguished between 4 types of laws, and stated that natural law is a part of eternal law. Duns Scotus and William of Occam stated that will dominates reason and not vice versa. The realists and nominalists argued about the truth of universal principles. While the realists considered universals to be real, the nominalists considered them to be of nominal value only. With this, I would like to end the lecture. Thank you.